The bone of contention before us is whether that jurisdiction ought to be exercised by this court or by the Supreme Court. As we have already noted, the final version of the 2010 Constitution marks a clear departure from previous constitutional texts regarding the jurisdiction of the Supreme Court. Specifically, the provision granting the Supreme Court exclusive and original jurisdiction over disputes arising from the impeachment of the President, that bit was deliberately omitted. The Supreme Court's jurisdiction is now strictly redefined under Article 163, Sub-Article 3. This leads us to the firm conclusion that the people of Kenya did not intend to grant such jurisdiction to the Supreme Court. Had that been the intention, the Constitution would have expressly conferred this authority in its final form. The Supreme Court has itself acknowledged that its original jurisdiction as outlined in the Constitution is exhaustive. This implies that any attempt to expand its jurisdiction beyond what is expressly provided for would contradict the Constitution's intent. Again, we refer to the case of Machari and another versus Kenya Commercial Bank, in which the Supreme Court itself stated as such. Article 163 of the Constitution provides for the jurisdiction of the Supreme Court in exhaustive terms, though leaving room for Parliament to prescribe further appellate jurisdiction in terms of Article 163, 3b2, which stipulates that the Supreme Court shall have appellate jurisdiction to hear and determine appeals from any other court or tribunal as prescribed by national legislation. The Supreme Court goes on to note that the Constitution also confers jurisdiction upon the Supreme Court to hear and determine an appeal from a judge who has been recommended for removal under Article 168(8). As far as we are aware, Parliament has yet to confer any further appellate jurisdiction upon the Supreme Court in terms of Article 163, 3b, Roman 2 above. Even with regard to the special jurisdiction previously conferred by Section 14 of the Supreme Court Act, which was repealed by Section 15 of Act number 26 of 2022, the Supreme Court was unequivocal in again affirming that this provision did not grant Parliament the authority to expand the court's jurisdiction beyond what is contemplated in the Constitution. The court expressed this position. Again, we go back to the case of Machari and another versus Kenya Commercial Bank and two others. It's important to read the text. The Supreme Court states as follows: what is the proper province of Article 163(9) of the Constitution? Does the article contemplate a situation where Parliament can confer further jurisdiction upon the Supreme Court? We hold that it doesn't. The act contemplated by Article 163(9) is operational in nature. Such an act was intended to augment the rules made by the Supreme Court for the purpose of regulating the exercise of its jurisdiction. It is an act that must confine itself to the administrative